Inmates in federal prisons can no longer be put indefinitely in isolation. That's because today the British Columbia Supreme Court ruled in favor of the BC Civil Liberties Association and John Howard Society of Canada. They challenged the federal government's use of solitary confinement. We're joined now in Vancouver by Josh Peterson, Executive Director of the BC Civil Liberties Association. Mr. Peterson, thanks for taking the time to join us. Why do you think the BC Supreme Court ruled in your favor and agreed that the Canadian government cannot put prisoners in isolation for indefinite periods of time?
Because it's torture. The way in which the federal government has been treating prisoners in its institutions who are in solitary confinement is essentially torture under international standards. This court today, this decision is actually the most significant prison law decision from any Canadian trial court in history. We've talked to legal experts today who verified that. And it's really significant because not only did he find that putting people in solitary confinement for unlimited periods of time is a violation of their right to security of the person, that it harms them psychologically, that it harms their health, that in some cases it increases their risk for suicide. But he also found, very significantly, that the regime discriminates against Indigenous prisoners, men and women alike, because a disproportionately high number of Indigenous people within the prison system are placed into solitary confinement. It is they, more than others, or disproportionately to others, who bear the brunt of this terrible treatment, which can include years on end in a small cell, sometimes covered in the walls covered in feces and food in terrible conditions for up to 23 hours a day. So it's a very, very significant decision, and we hope that the federal government will fix this system rather than appealing it.
As you mentioned there, the judge did rule that isolation is especially harmful to Indigenous and mentally ill inmates. Can you explain why?
Well, in addition to the fact that they are more likely to be placed in solitary confinement, and that once they're in solitary confinement, they spend longer there than prisoners of other races, it is fundamentally harmful to spirituality. People will not be able to have proper access to elders and to other ways in which to express their spirituality and their culture. They're deprived of many other opportunities, including opportunities for skills training, for example, and that kind of thing, so that when you finally come out of prison, you're more harmed, you're sicker, and you've had less opportunity to develop yourself while in jail. We had evidence from numerous Indigenous prisoners, but also from Indigenous elders who provide counseling to prisoners who are in the system, who testified as to the excruciating experiences that folks have had. One that many viewers may remember is Bobby Lee Worm, a Cree woman who is from Saskatchewan, who spent over 700 days in solitary confinement and has been working with us for about 6 years to put an end to this terrible system. Today this is a victory for her. It's a victory for all of the other Indigenous prisoners who worked in this case, who brought courage forward to put their stories in front of this judge, to get that judge to be there with them in those cells, to understand what their experiences were like. And we think that that is partly why he was able to make as strong a decision today as he did.
Mr. Peterson, we're running low on time, but what does this mean for people in isolation this very minute?
Well, the effect of the judgment was suspended for a year. But after 1 year, the federal government's law that allows them to do this won't be law anymore. We hope that the federal government, the Trudeau government, has promised, Minister Jody Wilson-Raybould has promised that they're going to bring a fix to this system. They promised it even in the election. So if they mean what they say, they shouldn't appeal this judgment. They should take this judgment as a guide for what they need to do to truly fix the system. They had introduced a bill in June of last year which was completely inadequate to solve these problems. They need to come to the table with prisoners groups, with groups like us, with others, to talk about how this problem can be solved once and for all. And I think it's important for people to remember to hear what the court said today. The court was explicit. They do not need to do this to keep prisons safe. Some people say, oh, well, what are we going to do if we can't isolate prisoners? There was evidence of all kinds of other alternatives that the government could use to fix the problem, other than putting people in these torturous and terrible conditions. And so it's now on the federal government to be true to their word and to fix this problem, not only for Indigenous Canadians, but for every Canadian.
The ruling states prisoners can't be held in isolation indefinitely, but does that mean prisoners will still be subject to isolation, and if so, for how long?
Well, what the court said is that there has to be strict and hard time limits. The international standard is 15 days, so the court pointed to that as a possibility, although it recognized that there was evidence in this case that even at times, durations less than 15 days, there can be significant harm already happening to prisoners. But the international standard adopted, called the Mandela Rules, adopted worldwide by the UN, that Canada participated in developing, say that 15 days ought to be the maximum, that there needs to be external judicial review of people's placement in solitary confinement, that there need to be alternatives. So there may still be some use of solitary confinement, but in 2017 there were over 8,000 uses of it.
Wow.
That should be much, much, much diminished, and we should be working as hard as we can to make sure that nobody needs to be placed in solitary confinement in order to deal with problems in the prison. The judge was clear.
Sorry, Mr. Peterson, we're going to have to hold you there.
Not enough staff, not enough services is not enough. Yeah.
But we appreciate your time. Like you say, a very significant ruling here today. Thanks so much for taking the time to speak with us about it.
Thanks for having me on.